Good afternoon, everybody. As Paul introduced me there, I'm a general practice surveyor. I operate several niche commercial and leisure property consultancies which operate across the whole of the UK and Ireland. And we cover all aspects of commercial and leisure property occupation and ownership. So through leasing, transacting, investments, rent review and lease renewal, through to what is probably the most popular activity for us in terms of retail these days, which of course is dilapidations. So I'm going to major more so on dilapidations today than on other items. Over the next 5 years, there is going to be a stark rise in the number of probable exits. About a third of all leases that have been granted in recent times, leases being shorter and with earlier breaks, about a third of those in terms of retail and food and beverage premises will come to an end either by lease expiry or break over the course of the next 5 years. And that could create a sharp spike in the number of dilapidations cases. So, reshaping and repurpose. So, the reason that we have so many voids, I'll not bother going into the story that we all know about the growth of e-tailing and decline of interest in bricks and mortar. But there is an oversupply, obviously, falling demand and functional obsolescence. Some towns are obviously affected far more than others. As a general picture for that, commuter towns have obviously been quite harshly affected over the years because of people not shopping locally, doing their shopping where their offices are. There are also many towns where there was already, prior to the last recession, an oversupply of bricks and mortar shopping facilities. We can all think of towns where there are perhaps one too many shopping centres and one or two too many retail parks. So oversupply and falling demand. But it's not all grim. What we're already seeing, certainly my colleagues and I, from an agency and acquisitions perspective, what we've been seeing through lockdown are is some growth in niche demand from click and collect, for example. So click and collect, we know of that term in the context of, say, Sainsbury's or Argos, other big retailers. But there are also niche retailers who are increasingly using click and collect, certainly some high fashion retailers. And we're seeing acquisitions in smaller towns where these retailers would not previously have been interested, because those towns now, of course, have more people captive for most of the week, people who are no longer going into work. Going into the offices often. And on the third point there, you see that offices equal customers. Well, of course they do. So central business districts have been very harshly affected during lockdown and will continue to be. We act for some very significant office occupiers, in particular some of the big banks, and they have, many of those have published figures in the past week or two showing that even post-lockdown, they are unlikely to return to anything more than 40 to 50% occupancy of their offices. In other words, with flexible working being the expectation going forwards, people will be working at home 2 to 3 days a week. Ipso facto, there's far less demand for the facilities in and around offices in central business districts, so shops and food and beverage facilities. So there will be repurposing, there'll be a lot of shaking out in those locations. Home is where the zoom is, the fourth point there. Well, suburban locations and commuter towns are actually likely to see an improvement going forward because there will be more people captive during the day shopping and using food and beverage facilities in those areas. So again, a positive perhaps in those locations. The next point, residential conversion. The much lauded saviour of many of the buildings that sit vacant, languish vacant on many high streets around the country. Well, as Nicola will cover in far more detail in her section, the new permitted development rights are easing the process for conversion of vacant space in retail properties and in particular on the upper floors to residential going forwards. But there is, of course, something of a north-south divide. The cost of creating that space is much the same, whether you're in Clapham or Wallsend, but obviously the economic viability of doing so is not the same. So as a rule of thumb, the further north you go, the less likely it is to be economically viable to do so, with exceptions like Harrogate or Gosforth or whatever. Last mile distribution, I'm referring there really to the fall of occupation on many retail parks, that's happening too, not at the same rate as the high street, but there are retail parks now around the country which have prevailing long-term voids, i.e. no likely future occupiers for units that fall vacant. And there are situations emerging now of these being converted and being leased for far less glamorous and in fact far less lucrative in terms of rental income uses, which are distribution and logistics, last mile as they call it, tends to be last 10 miles really, but last mile distribution. Smaller offices, many suburban towns are likely to see, suburban locations and commuter towns are likely to see hub offices, some perhaps shared office accommodation that we already see through shared office and serviced office providers, some being hub offices. For example, some of the banks we work for are looking to acquire smaller offices to accommodate their staff who are no longer going to be commuting in on a daily basis. Then on the next slide, we can move on to the key thing I'm going to talk about, which is dilapidations. So obviously this is a key event now and going forwards with so many properties falling vacant on high streets and in shopping centres and on retail parks. As I'm sure all of you are aware to a greater or lesser extent, dilapidations are dealt with primarily by chartered building surveyors. Excuse me, it is the building surveyor who identifies the breaches of covenants to repair, redecorate and reinstate, provides for what those remedies are going to be and prices them. Ordinarily, the tenant, the former tenant, appoints their own building surveyor and they negotiate to a costed settlement figure for the damages for those breaches. And that sum is the cost of those remedial works. Yet statute and common law that apply in England and Wales, Section 18 of the Landlord and Tenant Act 1927 in England and Wales, with associated case law, serve to cap those damages, that dilapidations claim, at the lower of the cost of those remedial works as negotiated between the building surveyors or the impact on the property's value. And more often than not, the impact on the property's value is significantly less than the cost of the remedial works. Yet, as I say, that cap, that protection, is all too often not used. So why is it not used? Well, as the bottom point there points out, the diminution in value cap, or DV cap, as I'm calling it in shorthand, it is the responsibility, unfairly, but the responsibility largely placed by the Dilapidations Protocol, which became part of the CPR back in March 2012, so going back 8 years now. It places an emphasis, perhaps unfairly, upon the building surveyor to advise certainly former outgoing tenants whether or not the diminution in value cap will assist their case. Well, that's not the building surveyor's discipline or expertise. The impact on the property's value is the expertise of the valuation surveyor, the general practice surveyor, i.e. my discipline. So there is this disconnect, this common disconnect between the two disciplines of surveyor, two distinct disciplines that are required. Why is the impact on value often lower? Well, most properties when they're vacated, in fact all genre really, require at least the modernising and upgrading works to make them relettable, and often complete repurposing, significant alteration works. If you think about it, if we use the example of some offices that have been leased for 25 years, that lease expires. If that property is vacated in perfect compliance, they never are, but let's assume it's in perfect compliance, it's still going to be trapped in a time warp. It's an outmoded, dated thing that's probably not really attractive in the open market these days. Modern expectations are of modern finishes, modern M&D that has a reasonable life expectancy. So there are works that the owner of a property is going to have to do in any event in order to upgrade and modernize it and often repurpose it altogether. And those works will often override or supersede a lot of what is claimed in terms of dilapidations. So that, looking at the third point there, is filter one, the first filter that I'm referring to. So the valuation surveyor is applying two filters, this is the first filter, to the building surveyor's common law costed works assessment. In other words, to remove items which, on the balance of probabilities, are likely to be destroyed or superseded by upgrades, improvements or alterations to that property to take it into its new life, to make it relettable again. The second filter applies the valuer's transacting or open market agency experience to remove items which are not value effective. Cost and value are not one and the same thing, yet the terms are often carelessly transposed. The law of diminishing returns applies. The case in particular goes back to 1894, Proudfoot and Hart, that the standard of repair expected judicially is that which fits with the age, character, and locality of the property. So to give you an example of that, if we're looking at a 10,000 square foot industrial unit or shed, and we've got two to look at, one's 40 years old, one is 5 years old, they're both suffering from the same breaches or items of disrepair in that they're a bit tatty, perfectly occupiable, wind and watertight, but they've got some dented cladding panels, some scraped paint on the floor, some steelwork that isn't painted. In the 40-year-old property, that's unlikely to affect the rental bid or the capital value of it, because that's the condition which fits with its age and character. It's expected and accepted. But for the 5-year-old equivalent, that's unacceptable. A higher standard, something more modern and clean and tidy and in near perfect repair would be expected. So each case on its own merits in applying those two filters. So it's the costs which survive those two filters, the bottom point there, the costs which survive those two filters, usually including fees, which actually equate to being at or about the amount by which the reversionary value has been diminished. So the traditional expectation, certainly in courts when dilapidations cases have been litigated, is that when the diminution in value cap is used, it will be presented by way of two distinct valuations. Valuation A being the property in repair, valuation B, the property in disrepair. Deduct B from A, and what you're left with is the amount of diminution in value. Great idea in theory, unworkable in practice. Valuation A is easy enough to produce. Full repairing and insuring comparables, similar property, similar location. There's your valuation in repair. But if you think about it, valuation B would require comparables again, similar location, similar properties, but also suffering from exactly the same breaches and which have transacted in the open market. One assumes at a lower level than they would have transacted at if in good repair, in order to show that diminution in value. But you don't get comparables for valuation B. Properties are usually or invariably leased in good repair or with a schedule of condition, whatever. So the practice that has emerged over the years is the making of valuation A and then deductions from that to arrive at valuation B. But valuation B isn't what is being sought. What is being sought is the amount of diminution in value. So really the focus needs to be on the deductions and the scrutiny of those in terms of those two filters that I've just described. In other words, which costs on the balance of probabilities, which breaches actually genuinely impact the property's value and which are in fact irrelevant, either because of the age, character and locality of the property, they don't matter, or because they're going to be overridden by upgrade and modernization and repurposing works. So the surviving cost is the key to it. In addition, now there is often a claim for loss of rent because of the dilapidations. Seldom is it justified though. Closer scrutiny normally shows that the period within which the dilapidations works would be attended to, remedied by the landlord, is usually the same length or even shorter than the market generated void period in any event, the amount of time the property would sit on the market. Or the landlord has their upgrade and modernization works to do, which would take at least as long as the time to remedy the dilapidations. So again, unless the dilapidations are entirely due, unless the delay, the loss of rent is entirely due to the time to remedy the dilapidations, there is probably not a valid loss of rent claim. Schedules of condition. Often properties are re-let without the works being done, but with a schedule of condition. And it is claimed that the schedule of condition evidences loss. Does it? So against that claim would be, from a tenant's perspective, saying, well, look, you've managed to let the property without doing any works to it. It couldn't have been that bad. And if you've let it with a schedule of condition, you should be achieving the full rent, the same rent as if it was in FRI condition. So there is no loss. Against that, well, if a property is in tatty order, chances are you're going to attract only lower quality covenant tenants, and that will affect your yield. Also, you would expect that tenant to commit to a shorter term because of the risk involved in taking on a dilapidated property, notwithstanding the schedule of condition. So whilst the rent might on the face of it be the same as if it was in good condition, the yield is probably weaker, and therefore that does affect the capital value. So arguments for and against. Dispute resolution, well, The Property Law Association published figures a couple of years, I think now ago, so well before lockdown, which suggested that even then, fewer than 1% of dilapidations cases actually make trial. In practice, alternative dispute resolution is, of course, promoted these days, and for dilapidations, that tends to be mediation. Mediations are quickly arranged, they are relatively cheap, certainly relative to going to court, will cost each party about £8,000 to £12,000 for the day. There is no award on costs. These costs are for each party in their own right, and that depends how many professional advisors they choose to have with them. Mediations do only last a day, might be a very long day, 14, 15 hours, but statistics published by the CEDR show that nearly 90%, 89% of cases which go to mediation do settle either on the day or shortly following. So offices, I know we're talking about high street retail, but offices and high streets are in many cases inextricably linked, as you'll appreciate. They provide the customers for the shops and food and beverage premises. So offices vacant, lack of custom. So here's an offices one from a tenant's perspective. Landlord's common law claim at 1.2 million, tenant's common law response 750, so not that much less. Our diminution valuation, this was provided through Radius Consulting, where we service mainly building surveyors and solicitors. So our diminution valuation was at 250. The settlement, as you'll see at 380, was half the tenant's building surveyor's response. The reason for that big distinction was largely what I was talking about earlier on. These properties were outmoded, so even if they'd been vacated in perfect compliance, a lot of work was required to modernise and upgrade them, which would supersede a lot of what was claimed for. Again, age, character and locality. These offices are in Chesterfield, less sophisticated office market. Our diminution valuation for the landlord in this case was at just under 600,000. The tenant's diminution valuation was at 60,000. Their argument, but without evidence to support it, was that these offices were likely to be repurposed, either gutted and modernised or turned into residential. But there was no evidence to support that. We had the evidence to show that there was a market for these offices just vacated in compliance. Ipso facto, the result there was £515,000. So this is through Dilapsolutions, where we provide both the building surveyors and the valuation surveyors, so it avoids that common disconnect I was talking about. Dilapidations for tenant. The landlord was claiming, as was covenanted, that the property be returned as a shell, in other words, stripped out of the tenant's shop fit. The tenant's shop fit was in fact only 5 years old, fitted out as a convenience store. Its most likely opinion was reletting as a convenience store. So when we stripped out that element, the stripping out and removal of shop fit that should have taken place, that reduced the claim to £45,000, which covered actual repairs to the building's fabric, and hence the result in that case. Then the next one is the opposite, retail for landlords. Similar arguments though, a convenience store, small convenience store, landlords claimed £27,000 for whom we were acting. So that was the building surveyor's assessment. The tenant responded and said, you'll relet this better with the shop fit still in place, which was correct. But our point was the shop fit needed to be in good repair, and it wasn't. So it was £17,000 to yield up in good repair so that it was relettable, hence the settlement in that case. Retail park for tenant, this was B&Q, who we were acting for in conjunction with their separately appointed building surveyor. The property had been relet to the range. The landlord's claim, so building surveyor's claim 235, tenant building surveyor's response 120. The landlord in that case supported their claim by suggesting that the £168,000 worth of rent-free period they had to give to the range to go in was because of the state of the property. However, when we examined local open market comparable transactions, we were able to show that, in fact, on the balance of probabilities, most, if not all of that rent-free period was simply market required in any event. In other words, an incentive to induce the new letting. Hence the reduction to a settlement at £50,000 as against our section 18 at 25.4. Fairly standard claim in a shopping centre obviously is, bear in mind that the lease is only internal repairing, the landlord maintains the structure and recovers that through the service charge. So the standard claim is to strip out and white box the unit. Claim therefore in this case 52 grand. However, when we went to re-inspect the unit, we found that it had been relet by the landlord with our shop fit in place. So where was the loss? Clearly there was none. So that was settled at nil, and that's common in shopping centres. It's often claimed that when a landlord has done the works, they've proven their loss, they've crystallised the loss. That's not actually the case. So this is an example because it involves a couple of high-profile landlord, high-profile building surveyor, neither of which should be named. So it was Aviva that owned the property and Hollis acting for them, and their claim was 150,000. You will see the 3 upper floors on that white building. They had all been rendered absolutely immaculate internally, yet no retailer, very few retailers, have demand for upper floor space these days. When we looked at their lease, the new tenant's lease, Hotter Shoes, we found that in fact they were excused from any repairing and maintenance liability in respect of the upper floors. So they were really just otiose and void. So our argument was that the works that had been done in there were excessive, added nothing to value. So long as they'd been left tidy but not immaculate, it would make no difference to lettability and value. So the ultimate settlement against our DV at 70,000, notwithstanding 150 actually spent, the settlement was £75,000. So I said I have 4 different consultancies. So Dilapsolutions and Radius Consulting deal with dilapidations. The other 2 are what inform the judgments that we make. So transacting properties, agency, etc. And then the last slide, we have an app. The app is called Dilapse. You can download it from either store. It gives guides as to how dilapidations operate in the different jurisdictions around the UK and Ireland, case studies, and a diary of experts or a catalogue of experts you can access around these different jurisdictions. So you don't necessarily have to use us. So I hope that's been of some guidance to you in terms of dilapidations in the current landscape on the high street and in shopping centres. Nicola will explain to you next how we're going to improve and reshape the high street going forwards with planning advances. Thank you very much indeed.
Just by way of explanation, this is going to be quite a high-level discussion about the planning system at the moment. As anybody who practices within it knows, there's been an awful lot of changes. They started really under the Conservative government, but also due to COVID and also the problems within the high streets that are already recognised, they've accelerated very much. So it's great. I'm leading with slides with Boris on them because then it's really easy to remember what Boris has said. And I don't know if people do remember this. Boris's message to the nation, this was on the 30th of June. And if you can see, he's looking not terribly well. This is just after he's had COVID, but he started talking about things being shovel ready. Brexit was oven ready. The built environment became shovel ready. So basically this was his build, 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 or build back better. Boris obviously likes his little short phrases with only 3 words in them so that he can remember them. The thrust of this was very much on infrastructure. He was expressing a view that he was going to support the NHS, schools, new road infrastructure. So for example, the widening of the A1 was mentioned at this point in time. So it was very much positive. And the planning system was expected to start to deliver. So the major amendments that I'm just going to talk about today are really how the planning system has responded with as permitted development by widening the permitted development rights. So these are the first real changes that came through, and this was on the 23rd of March. This was a week after lockdown, and suddenly the government managed to produce an awful lot of new statutory instruments to help the economy and the built environment. The general thrust of it all was to loosen the grip on planning, introduce new flexibility and expand permitted development rights. And people who work in property will recognise that this started really when Boris came into power, and it's just carried on. So if you look at the First Amendment, I've just put this slide up because I love the speed at which the government can move when there's a crisis. And this is the header from the legislation. So we went into lockdown, I think, on the 16th of March. It was either the 16th or the 18th. It was the 16th. Everybody was panic-stricken. The government was trying to respond. They were obviously running around doing the best they could. And therefore, this was the first substantive permitted development change that came in. So it was made at 10:42 in the morning of the 23rd. It was laid before Parliament at 1:30, so by lunchtime, and it came into force at 10 o'clock the next day. So I think we have to admit that the government was certainly keen to get on with some of these provisions. I like this one because this was when we found out that pubs were going to close down, and we all had a bit of a panic and thought it was going to be very miserable. And the government decided that they were actually going to try and support the hospitality industry and allow them to do takeaways. So I've called this Make a Plan, Have a Beer, because I remember it was very hot and sunny and the pubs were shut, but you could actually go and sit in the car park in a teepee or something. And basically any of the hospitality uses, A3 and A4, or any of the mixed uses, they were then allowed they were allowed on prior notification, sorry, not automatically, to allow people to use the outside space, and also they were allowed to serve takeaways and alcohol. I think if we remember, at some stage the government stopped them serving takeaway alcohol because they thought it was bad for us. So this was in place for a year, so this is still live. It applies to buildings and land, and the operators of the pubs are supposed to tell the council by prior notification, but I have to say my experience up here is that the councils were pretty relaxed about it and probably far too busy dealing with other issues such as maybe care homes or adult social care. As I say, later in lockdown this was modified, but generally pubs have been allowed to continue to serve takeaways. Just moving on, this goes back to Boris, who was build, build, build. So the first build was really build up. I was quite surprised by this, I have to say. This came in July 2020, and it's a new permitted development to build on top of existing buildings. I haven't put in all, this is very high level, so I haven't put in all the different criteria that you have to meet. I've just highlighted what I think are the important ones. So basically, if you had a detached or a terrace building, there were slightly different criteria for the two buildings. Basically, you can build up and add 2 additional stories on top for housing. So you can do this very importantly in relation to the high streets and retail areas. You can do it on top of shops, financial and professional services, restaurants, cafes and offices. Or you can do it on a building, say for example, that's already in a mixed use. So it might have commercial at the bottom, a couple of stories on top that are already in residential use, and you can build up again. There are all sorts of limits. Interestingly, it only applies to buildings that were built from 1949 to 2018. So it doesn't apply to all buildings. Each story has to be 3 meters. I suppose that makes complete sense. Of course, it doesn't apply in the restricted areas such as conservation areas, national parks, the AONB, SSSIs and listed buildings. So that seems reasonable. And the information, it's a prior notification procedure, so it should be a quicker procedure for developers. But developers do have to tell the local authority what the impact of the building is going to be. So there's a prior notification, and for example, you will have to notify, perhaps send a transport statement, a contaminated land assessment, flood risk assessment, and more recently, details of the natural light within the proposed houses, because that's a new issue which is becoming very important within the planning system. Here we go. So the next slide is Boris's complete new rebuild. I find this to be one of the most radical new permitted developments that we've seen recently. It's called Class ZA. This came in August 2020. And this applies to buildings that have been vacant for 6 months. So given that we went into lockdown in March, I think perhaps it was a reaction to that, and maybe just to give people an indication that there might be a way out to free up some of these buildings. It applies to detached buildings. They're described as purpose-built flats. It also applies to a single house, and offices, research and development. So again, some of the town centre uses can take advantage of these provisions. And it's quite a stark permitted development. It gives permitted development to demolish the existing building and rebuild it for housing. Obviously, there is a limit. It's 1,000 square metres footprint, but that can be in any configuration. So my view is, for example, it could apply to a purpose-built block of flats, but I don't see any reason why it shouldn't apply to a terrace. Maybe you had a 50-metre, 20-metre terrace. There's a height restriction of 18 metres, and basically you can add 7 metres in height. So that's another, if you say you have a building already that's 4 stories high, you get permission to completely demolish it, and then you get permission to add another 2 stories with your 7 metre on top. So again, that's a radical, very broad range in permitted development. Again, it's a prior notification, so it should be a more straightforward procedure than a planning application. And again, you do have to provide information on highway impact, contamination, natural light. So whatever the impact of that building is going to have on the neighbouring buildings or the environment, then you have to provide that information to the council so that they fully understand what's going on. Another substantive piece of legislation was the Business and Planning Act 2020. This came out in July, the 22nd of July. It was in 2 parts, really. The first part were a lot of the transitional provisions that the planning system had to try and keep the economy moving and try and support town centres. So, for example, some of the transitional provisions that came in, pavement licensing. I don't know if people remember, again, it was still hot and sunny. It was a bit continental in Newcastle, and it meant that they could, say, for example, the bars on Grey Street could allow people to sit outside and enjoy themselves. It also permitted off sales, so that was more flexibility for restaurants to have off sales. And in connection more so with the planning, there was a fast track so that people who were working on sites who had already been shut down for the first shutdown could vary the construction site working hours, and there was an expedited procedure for that. More importantly, within the planning system were these automatic extensions to permissions. I actually had a client that was ready to go on site and had to do some demolition during lockdown, and we literally had to get a demolition company at cost to come out on a weekend and demolish a building. Otherwise, we would have lost planning permission for about 30 rather valuable apartments. So this did eventually catch up. This wasn't issued until July, and it was backdated to March. So in the first March, so the first 6 months of COVID, 23rd of March to the 19th of August, the permission would be extended, but if you had any environmental issues or had submitted information under the habitat regulations or to do with environmental impact, you had to update and add to that information. So that was quite onerous on developers. And what happened in the second wave of the extensions is from the 20th of August till the end of the year, all the permissions were automatically extended to the 1st of May this year, and there was no need to send in the additional information. I think the councils and the government realised that that was unreasonable, and it was just really clogging up the system. The other automatic extension, which helped everybody out, was that outline consents, they again, if they were going to expire and you hadn't got your reserved matters in, then those were extended to the 1st of May. So that meant you got an extra year on your outline permission. The other mechanism that was put in place is that appeals started to be heard remotely, and they also had the hybrid appeal hearings. I don't know if anybody's had an experience of the appeal system. It's still going grindingly slow, and that is a real problem. But you know, that's the best the government could do, I think, and that's what they did. So Boris was on build. My view is a lot of what was going on substantially within the planning system was change. And the big substantive change, I think, really came in September 2020. This was the most radical shake-up that we've had of the use classes order for years. Very much impacts on the high street because it's to do with commercial and business and services. Basically, what Class E has done is it has amalgamated a lot of the old classes, so the A1, A2, B3, B1, together and put them into one composite Class E. So all your retail sales, restaurants, finance and professional services. It's also brought indoor sport and recreation. And I think that's a nod to the fact that we have quite a lot of high street gyms and maybe dance classes nowadays. The medical and health services were brought in, and also creches, day nurseries, and then other high street uses such as office research and development, and also the industrial uses which can take place without detriment to a residential area. So all of those go into the new Class E, and of course that means that people can now freely move between all of what used to be quite different and distinct use classes without the need for planning permission. Interestingly, certain high street town centre uses are excluded. Public houses, drinking establishments and wine bars, they don't have freedom of movement, and public houses have now become sui generis. And I think that's actually to give them more protection, because they're classed as being an important high street use, and also worthy of protection maybe as a community asset, for example. Hot food takeaways were excluded, and also these lovely old-fashioned concert halls, bingo halls and dance halls, they remain within a use class of their own. So just moving on, those are the main issues I've got to talk about on permitted development. This is Boris in October. We last saw him in June. He was looking a bit rough. He looks a bit better now, and he's got his pecker up, I feel. And he did this lovely rallying cry speech, which he called levelling up. And I think people will remember this, even if you don't particularly work within the property industry. It was Manchester, yes, it was Manchester Science and Industry Museum. There he is in front of some industrial machinery. I'm not quite sure what it is. And he's basically rallying the troops and telling everybody in the north of England that he's come to Manchester, which Boris classes as the north of England, and that he's supporting us. And one of the announcements that he made was the towns deal. Now, interestingly, this is an initiative that started in September 2019, so it started well before COVID, but the Conservative Party agreed to put an awful lot more money into it, and 101 towns were invited to apply for funding. And I think if you remember, there was a lot of gossip in the newspaper that many of these towns seem to have a recently elected Conservative MP within them. So this was really the blue wall of Northern England. The first round, 7 towns last year were successful. So that's Barrow-in-Furness, Blackpool, Darlington, Peterborough, Norwich, Torquay and Warrington. So as you can see, a bit more than half of those are genuinely northern towns. Darlington was one of the very first northern towns to be successful, and they were awarded £22.3 million. And it's on the basis of a very specific initiative and bid. So that's the area around the station and the cattle market. So Darlington had identified the Northgate area of the town that needed investment, and were successful in their bid. Workington is in with the next round, and they're hoping to be successful. These are the sort of initiatives also where we've had investment in Teesside and also in Hull with the offshore wind industry. And of course, we've heard today, I think, in Rishi Sunak's announcement that the Treasury Department's going to Darlington, which is expected. So I know everybody in Darlington, I don't know if we've got anybody online today who's listening in Darlington. I imagine there'll be quite a bit of cans of beer and a bit of champagne corks popping in Darlington tonight, because they are doing very well, attractive inward investment. Interestingly, also other initiatives, the Conservative headquarters are looking to go into Leeds. We've got the new big factory in Bath that's going to make the batteries. The Conservative government are showing a lot of support for that. So these are all good news stories. Now, that's the sort of broad brush approach. One of the issues with the government bringing in permitted development is there are often regional variances as to how the local authority feel about it. And they're often subject really to local interpretation and influence. So my view is the devil's in the detail. And this is just like a little bit of a case study. I apologise, it's not from the north of England. But what's happened is the PD has been exercised in the south of England, and we've actually seen applications now coming through to the inspectors on appeal, so we can see how the inspectors are dealing with them. So this is St Catherine's Place, which is just like a district shopping centre near the centre of Bristol. And the plans were to regenerate what was called a rather neglected shopping centre. You'll see when I show you the slides what that means. A developer had come on board, and basically they had already taken advantage of permitted development. They'd turned one of the office blocks into a residential block, and then they were promising a new cinema and more residential development. By the time it got to appeal, the only issue between the parties and the only issue the local authority was raising was the design. And part of the issue with the design was also the living conditions of residents. One of the issues recently with a lot of the permitted development in the south of England has been that office blocks have been turned into residential, and they don't have the appropriate levels of sunlight, and the rooms aren't really adequate for purpose. So the government's brought in some new requirements about room sizes. So they're actually looking much more at the detail of these schemes, even though they're talking about the PD. And I thought this was just quite interesting. I've just put a little excerpt from the inspector's decision. The appellant was basically saying, oh, it doesn't matter if you haven't got enough sunlight coming into your house. It's just a bit like putting a jumper on when it gets cold. Obviously, the inspector didn't attach a lot of weight to that, and this scheme was refused on design grounds. So I've just managed to find a few photographs just to sort of illustrate how this permitted development's working, for example, in a district centre. So just top slide, we've got the before photograph. You can see it's like a 1960s rear of High Street, small shopping centre. And some of these are looking very tired. These are the sorts of buildings that Paul will be looking at dilapidations on, I imagine. And then if you see just at the bottom, this is an image of what it's going to look like. The taller building, I think I'm correct in saying, has already been converted to resi, and basically the developer is putting more residential in medium and high-rise blocks around the site. So that's a sort of working example of some of the permitted development.
I'm going to take a positive view, and I'm going to do two things. First of all, I want you to imagine three things, two of which might be unlikely, and one of which I hope is happening to you all. The first thing, I want you to imagine that you're actually in your office or your offices. I suspect a large number of us are working from home, and therefore we haven't seen our offices for a very long time. But I want you to imagine you're in your office. And secondly, I want you to imagine that the sun's shining, which at least now where I'm living at the moment, which is or staying or working, is about 20 miles north of Portsmouth, is not very sunny at all. So there we are. Thirdly, I want you to imagine that a client in different shapes and sizes, or clients of different shapes and sizes, have come through the door and want your advice. Now, when I refer to the high street, that includes everything from the traditional high street to shopping malls, the Trinity Centre in Leeds, big centres in Manchester, central and out of Manchester, the Black Country, everywhere right down to the dark south, where we have huge centres in places like Southampton and Westfield in Stratford and Shepherd's Bush and everything else. So it's everything from the traditional high street, the retail streets that, for example, Nicola very helpfully showed us with the mixed uses, right through to the big super deluxe malls, which have often got integral cinemas and eating places and everything else combined. Now, the question I'm going to be looking at in that context is, with your hypothetical client, what do our clients need to know about real property law? Paul has very helpfully given us an extremely useful lowdown on what will happen under landlord and tenant law, particularly as regards dilapidations. And Nicola has very helpfully told us about what the government's done and the planning rules and the changes to the various use classes orders that are all designed and were, as Nicola has shown, put in at remarkable speed to try and assist people with regards particularly to change of use in all sorts of different contexts. But underlying all that is I hate to use the phrase, is a major problem. In 2011, almost 10 years to the day, the Law Commission published a very large paper on the reform of easements and covenants and a few other things, which would lead the way to releasing land from the grip of all these rather strange rights, which I spend probably too many of my waking hours trying to look at. And then in December 2014, so that's over 6 years ago, we then had the reform proposals of the Law Commission on rights of light. Now, of course, we all appreciate that in certainly the last year or two, the government's had other things on its mind, from Brexit to COVID, and that's understandable. But the problem we have at the moment, without wishing to overstate it, is that in terms of trying to free up land use, there are some serious problems that face developers of all sorts and sizes, which ultimately cost a lot of money to resolve. And in simple terms, as I put it in my response to the planning white paper in August, and I've also put it in my response to the latest MHCLG paper on reinvigorating unused land, the problem is, or the cost of it all, leads to the bottom line of developers being less bulky than it might have been. And in very, very simple terms, the block of flats or the houses are going to have less good quality bath taps than they might have been if all these legal problems did not exist, and those of us within the legal surveying, etc., fraternity were not having to be paid good money and pay lots of release fees, etc., to those with the benefit of this right. So we do have an unfortunate position when we come out of all these dreadful businesses of lockdowns. We do have a slight difficulty in that the law is still very early 20th century, 19th century, and of course, those of us who do anything about rights of light, going back to the start of the reign of Richard I in 1189. So that doesn't help. I want to show us how we can go through the hoops of improving or giving our advice to the clients in a constructive way. The reason why I said that you have to imagine that you're sitting in some sunshine is because we have to imagine that on our desk we've got a four-sided prism. And as we all know from our physics law, some of us a very long time ago indeed, light which travels in direct lines then can get refracted into all, in simple terms, the colours of the rainbow. And it's those colours of the rainbow that sometimes we have to identify when we're looking at a legal problem. In other words, the legal problem will cover the spectrum of the splitting of light through the four-sided array prism. Now, it's an iterative approach. In other words, it's a process of stages. Now, I say this, and I'm not trying, of course, to talk down to anybody here, but I say this because we're all working, and curiously in the COVID world, we seem to be working under increasing pressure. We're all working under pressure. And our proverbial client who's walked into our office will, of course, want the answer the day before yesterday. Or if you're working for local or public government or other bodies, your betters, if not superiors, will be also wanting the answer, because there's a committee meeting next week, and also there's some government funding which is going to run out tomorrow if you don't get the answer right. So we're all working under huge pressure, and the temptation is to run at the problem without looking at it in what I might say very simply is a stage-by-stage manner. So the iterative approach, I've got 4 stages here. Now, I'm dealing with the sort of high street that Nicola was throwing up from Hexham, where, for example, we've got restrictive covenants on use and all sorts of other things. I'm ignoring easements and things for the moment. The first question that the client will want to know is, what do these restrictions mean? Now, that's a very important question, and it can be, of course, in a freehold covenant and, of course, in user covenants in leases. Am I prevented from taking advantage of one of these new use classes orders, from changing my use from a restaurant to a takeaway, or from retail to flats? Does it stop me? And I do find, I'm afraid, rather almost not quite continuously, but commonly, that folk aren't looking at the words. Because of such a rush, they're not looking at the words closely enough. And therefore, when often matters come to me, I'm actually pleased to say, from the point of view of, for example, the developer, I can actually say, well, what are you worrying about? What you're proposing to do is not going to be a breach of this restriction or covenant or whatever at all. So that's the first stage. The second stage is, what facts are relevant and key to the advice that we are going to be giving the client? And that's where we start digging, almost as in the Boris Johnson phrase, we're shovel ready. We've got to get our shovel out and start digging the pile of gravel or coal, wherever it is, to find out what's in there. And that's, again, can be a tedious process, not just land registry transfers or land registry office copies, but also looking around buildings, if it's prescriptive rights, etc. What's around us in the high street in Hexham? What about the houses or the buildings or shops next door? Have they got prescriptive rights of light? That's not going to be on the register. The third point, the key again to advising our client, because that's what he or she will want to know in your sunny office, is, where does value lie? How can I get the best value for my site? This is where, of course, Paul will come in, Nicola will come in on the planning side, I will come in and say, well, you could do this and this and this, and of course, unfortunately, it's going to cost you that, and therefore the economic cost benefit is absolutely crucial right at the start. And of course, the legal, surveying and other professional costs will often be dictated by what we can or cannot do and what routes we might take, whether to the court or the upper tribunal lands chamber, for example, to sort out what might be a problem that can't be resolved by agreement. And the fourth problem, and this is not the fourth point, this is not just a plug for your panel today, but this is very important, as I'm sure you're all aware. It's the key stage of getting specialist advice, and at a very early stage. I always say to my developer clients, think pre-planning, and I'm sure Nicola would endorse this. Think pre-planning before we put in a very expensive planning application, or even go for pre-planning advice. And even before we might be wanting, or we may be doing at the same time, of consulting Nicola to advise us, no doubt extremely well on the planning side, who else do we need to bring in to advise us on what the other gaps are in our specialist knowledge? And you do need, I'm afraid, if it's rights of light, specialist rights of light surveyors. If you're dealing with covenants and releases, you need specialist surveyors who deal in the upper tribunal lands chamber. It's no good just having a local estate agent or local valuers who've got no experience of this whatsoever. And the other point I make very simply here is the four sides to this prism with the sunlight coming through it is pretty much the way the judge is going to be looking at it. If I'm in court and I'm bringing in my advocacy experience here, as I'm sure Nicola would, we're looking at this from the point of view of a judge who, in our adversarial system, is going to have to assess all the evidence on the civil standard of proof, which is on the balance of probabilities, looking at who has the burden of satisfying whatever burden it is, and looking at all the relevant facts and evidence. So I always say sometimes when I'm advising clients in these circumstances, let's imagine that we're going to present the case to court tomorrow. What are we going to need to do? So anyway, that's your client in the sun-filled office. I'm going to give you now three examples, or two examples, different examples of the problems that can come up and where they can actually come, especially if we're the developer or land user, to our advantage. And these aren't all terribly well known, and they're rather specialist, so I'm not going to make particularly heavy or detailed weather of this, because this can be slightly troubling unless one spends at least half a day trying to boil one's brains on it. First of all, a reasonably well-known area of law, it's been the case for now 10 years, since 2011, that covenants over land, whether in leases or freeholds, etc., are within the European, originally conceived European law on competition, which has been since 1998 in the Competition Act. So since 2011, land agreements have fallen within the jurisdiction of Chapter 1 of the Competition Act. And that involves considering whether covenants are either by object or effect restrictive of competition. And the two or three, many cases on this, but two or three leading ones are carte bancaire, which was in Strasbourg a few years ago now, and then more recently in the Competition Appeals Tribunal, the Sainsbury's supermarket case. There is, of course, a fair bit of what I might call European and homegrown law on this, and the best place to ever start it with this is the Competition and Markets Authority guidance notes, which are available on the internet. That's, of course, an extremely important question, or the question is whether they in conflict with Chapter 1, because if they do, they're void. And therefore, if you've got the argument that, for example, in the street in Hexham, that Beale stores could actually open up doing something, notwithstanding a restrictive covenant, that might, the former Beale store, that might conflict with the property opposite, then if that's a trading covenant that is void under the Act, then that's the end of it. The second question, which has come up very recently in when we were all napping in August in the Supreme Court, was the Peninsula and Dunn Stores case, which is old-fashioned common law restraint of trade. It changes the law to an extent because it gets rid of a rather curious test that went right back to 1967 in Harper and Esso Garage. And very recently, in fact, a week ago, as I was actually in the middle of presenting one of these seminars, the Court of Appeal decided similar questions and applying Peninsula in a case called Quantum Actuarial. That's the abbreviated title to it. But you've still got to show unreasonableness, and it's almost a similar set of evidence tests that will be required under Chapter 1 of the Competition Act. So does this affect competition, on which a lot of you probably will know if you're involved in this, there will be a lot of economic and sometimes potentially expensive evidence as to the patterns of consumption, consumer trading, etc. But the good news from the client, let's suppose our client wants to open up as a supermarket, or not so much a supermarket, but possibly one of those shops that sells lots of very good quality, locally grown food and everything else, and vegetables and meat from local farms. There's a trading covenant that says he can't do that. Well, that may well be void. And this is, of course, assuming somebody's got the legal benefit of it. And then we have the question of challenge. There are three ways to challenge this without getting too deep in procedure. You can either go and ask the High Court for a declaration, or you can go to the tribunal and say this covenant's obsolete, or it's not capable of securing any practical benefits because it's void, or there's a fast track course now been around for a couple of years to the Competition Appeals Tribunal, has to be done within 6 months under Section 47A of the Competition Act. So that's the way we can bring that to the fore, and that's something we could tell our clients this afternoon. Number two is a little bit more specialist and less well known, but still jolly handy. We had a trio of cases, plus some other ones in the Upper Tribunal Lands Chamber, and some of you may be familiar, or many of you may be familiar with that jurisdiction, to discharge or modify covenants over land. And by Section 84, subsection 12, the one that we read last, long leases, which are in broad terms long leases and not mining leases, if they contain covenants that are restrictive of the use of land or building thereon, the tenant can apply to the tribunal even though his landlord won't agree to the change of use. Now, the first thing we had to remember in this type of jurisdiction is that we must use the right gateway, and that's usually paragraph AA, no practical benefits of substantial value or advantage, etc. We're not dealing in the high street with the usual views over people's gardens and parks and lovely birds twittering in the trees and all the other things. It's a bit more like Boris Johnson standing in front of, I think that's actually the original of Stephenson's rocket, which was puffing around about 150 years ago, but that's another point. But anyway, it's a little bit going to be more of an industrial or business context. And the leading case to read on that, it's a couple of years old now, is the Pendennis, the Falmouth shipyard case, which is key reading when you're looking at the effect of competition or the effect on competition and businesses if you're seeking to try and improve or modify your covenant to allow you to do different business that might compete with the next doors. That was a case, in fact, in which the, for various reasons, in fact, the invalidity under the Act, etc., was not a point that was not taken. So we have, therefore, the position that we can go to the tribunal and just skipping out compensation for one moment in the middle part of the slide, we can look at the three cases that were decisions in a row, a bit like London, if not Leeds buses, all at once by the tribunal in long lessees applications. Chavaram was a case about a very tired 1970s former IBM offices just outside Basingstoke Station. The freehold was owned by the local authority, Basingstoke and Dean Borough Council. For reasons best known to themselves, and they didn't come out terribly well in the tribunal, they were refusing consent by the tenant to convert these tired offices into residential flats, which literally a step from Basingstoke, which is a very important commuter station on the way down to Bournemouth and Southampton, would have been ideal. Unfortunately, Basingstoke was saying on the one hand, we don't want you to do this. On the other hand, wearing its planning authority hat, which I'm sure Nicola has seen many a long time, was saying, actually, we want to promote this as part of the sort of Basingstoke gateway. So yes, Basingstoke gateway with all the other fancy ideas that came with that, but not you change use. In the application, the tenant won. The second one was in central London, in the West End of Mayfair, Berkeley Square. Some very fine grade 2 William Kent houses on the west side of Berkeley Square, about the only bit that's not been ruined in the last 100 years. And that was where they wanted to convert a rather mixed batch of properties into grander and restoring them back to grander uses as private clubs, etc., etc. And that one got through too. I should add that the lesson in that case was that the objectors, who were one of the Middle East investment offices, were very coy about what land they owned in that area, and therefore the tribunal held that they couldn't present any real objection because they didn't tell anybody what they really wanted and what the effect, for example, on their reversionary interests was going to be of this change of use. And I should also add, just before proceeding to the third case, that the lesson we draw from Chavaram, the Basingstoke case, is that the fact that the local authority might have granted planning consent, and as I'm sure as Nicola will know, or might have promoted this in its general planning consultations, papers, etc., local plans, doesn't add a pennyworth much to whether or not you're going to be the covenants removed. The fact that planning consent's been granted and the fact that the planning history is a mandatory piece of evidence under section 84(1) big B has only a marginal effect, really. It's just simply relevant but not persuasive evidence in favour of the application. So one of the problems we often find is our client, the developer, coming into our sunny office will say, well, I've got planning consent. How is it therefore that the owner of the developer, how is it that the owner of the local planning authority is still objecting? Well, I'm afraid it's wearing one of its many other hats. Edgware Road, about a quarter of a mile up from Marble Arch, was a case where the Crown Estate had a big estate towards Paddington, west of the Edgware Road, generally held in reversion. It had the reversion on a 1960s, pretty grim 1960s shopping and office development just before you get to Sussex Gardens on the west side of Edgware Road, say half a mile up from Marble Arch. And that was where the applicant wanted to convert some disused offices into a sort of pod type hotel, it wasn't necessarily the objection that by the church commissioners this was going to encourage riffraff, but they felt that it was against the interests of their estate. And the member made the decision to dismiss the application. A lot of us who delve into this world thought that was a wrong decision. I heard last week that Lord Justice Newey has refused permission to go to the appeal on that one by the applicant. They may well be an oral application, and we'll have to see what happens then. Just finally, in terms of practical advice, your client who's coming to your office, he may say, or he may be actually the opponent. He or she may say, well, I'm entitled to huge amounts of negotiating damages. I'm entitled to 30% of the net development value of this great thing next door. Well, the answer is no. If you're in the Lands Tribunal, if this is a covenant as opposed to an easement case, you're not entitled to that, because the compensation in the tribunal is generally going to be based on losses in capital value. And that's an extremely important factor when you're negotiating for the developer in the proverbial virtual smoke-filled room, because you can look at the objector and say, well, forget your ideas about having 30% of £1 trillion. Finally, you will be relieved to hear, adverse easements, as I said right at the beginning, the 2011 reforms, 2014 reforms proposed by the Law Commission, still not in force. So if you've got problems with rights of way or rights of light or other rights, services, etc., you can't go to anybody to get them discharged or modified. You might have to get declaratory proceedings afoot, or you might have to go to the land registry first tier tribunal to sort them out, but there's no Section 84 jurisdiction yet. Don't forget the Party Wall Act. It's something that still catches people unawares, even though it's been around now for 25 years. It's just as present in our proverbial high street as it is between two semi-detached houses. If you're dealing with development where there's rights of light, there are some very highly technical traps under particularly the Rights of Light Act, where light obstruction notices have been registered. It's a highly technical area, but there is a particular trap that if you're the developer and your client's coming into your sun-filled office and says, look, I think the building next door is about 17 years old, or the apertures have been there for 17 years, you will need to get on and register your light obstruction notice, because there's a curiosity under the Act which gives the dominant owner, in other words, the claimant to light, an extra year. So it's not 19 years a day, it's 18 years in a day, in very simple terms. So watch those traps as well. And I'm also interested to hear what Nicola said about local planning authorities giving far greater importance on natural light, which I think is far more important sometimes, and the BRE guidelines aren't always terribly satisfactory on that, because we do have this two sets of rules, the civil standard, the one lumen, the 0.2% sky factor, and our BRI guidelines, which are of course different. If you're in the middle of Hexham, you might be able to get the local planning authority to override, or in Grey Street in Newcastle, or anywhere else for that matter, or in the Hedgerow in Leeds, you might be able to get the local planning authority to override any nasty little interests that people won't release under Section 2 or 3 of the Housing and Planning Act. That used to be Section 237 of the main Act. And then my final point made in red, the new planning freedoms that Nicola has very ably explained don't trump real property law restraints. So your client in your sunny-filled room will probably have to have that piece of advice if he's the developer, he or she is the developer at the end of it. So ladies and gentlemen, that is all I propose to say today. Thank you very much for listening. And I think it's now time to hand over.
We've got three very, very different parts of the jigsaw puzzle, basically. On the high street, you'll have a building that's coming to the end of its useful life. It's coming out of lease, and everybody, including landlord and tenant and Paul, are looking at really the future of that building. I've explained the planning system's been really positive, but Andrew's very rightly said, and he put it in his red letters, that doesn't trump private interests. So Andrew, what would your advice be to somebody about where to go first. You know, it seems like it's almost a chicken and egg. Do they go to Paul first and see what he thinks about Dilaps? Do they come to you first and see about the strength of their argument on restrictive covenants?
I think it's actually a case of bringing everybody in at the first stage. Paul, Nicola, me, other surveyors, valuation surveyors, you know, behind you, Nicola, there will be the town planning consultants.
Yeah.
The key thing, it's often, again, this is point about everybody being in such a hurry, is looking at the documents. It seems to be, I think it may be the land registry typeface is very off-putting and often rather faint. There's sometimes a reluctance people to actually start reading what's there. And so the client, the mythical client, comes into your office and says, I'd like to do this and this and this. You know, in the Hexham High Street, he's bought the former Beales stores. We've got a Dilapse problem possibly for Paul. We've got a planning problem possibly for you. There will be, you know, all sorts of other folk looking at the listing. Let's assume it's a listed facade and how we could retain that, and structural engineers. So I would be very happy to say that it's really a job, and again, it's bringing back the point I made, which is having all the specialists in from the start. Because I'm sure you've seen this, Nicola, and I'm sure Paul's seen this, that people spend a lot of money, clients spend a lot of money and time and everything else at the initial stages, and then suddenly they're brought up short. I mean, my instance is they were brought up short by injunctions. I've got a case of the Lands Tribunal at the moment where the chap's built the thing and he said he didn't know about the covenants. Well, we've got some serious problems there. They're all on the title, bless him. And so there's no point bringing in lots of expensive folk until you've worked out what you're going to do or what you can do. And it may be, and the other point I only mentioned very briefly, here's of course the other thing is bringing in the insurers, because there may well be indemnity insurance available here if I can say the covenants aren't worth the paper they're written on. So that again is good news from the proverbial client in the Sunnyfield office. Yeah.
Lovely, thank you. Thank you, Andrew. I think my view, having heard from you, Paul and Andrew, is probably to endorse what you've just said, Andrew. And really, there's got to be quite a bit of joined up thinking. I don't just say it lightly, you know, go and get professional advice. But I find the planning system and all these new regulations that have come in the last year are quite complex, and you really have to go through them carefully and be able to advise your clients exactly what their options are before they then decide to get more professional advice from other people or to go ahead and buy a building. I think that's my overwhelming view from what's happened today.
You've also no doubt seen this, Nicola, yourself in planning inquiries, and I've seen it because I read particularly planning inspectors' reports on refusals when they're allowing the appeals. And a friend of mine, I was just speaking to him this morning, is a retired judge who's now starting off retraining himself as a planning inspector. And he says that, you know, even as a judge, where he has to deal with detail, the detail of the training he's doing at the moment on the planning inspectorate side is phenomenal. And there is so much there. And as you rightly said, it all lurks behind these statutory instruments that are almost changing by the day. And that's, you know, that's the key. And we do have to sometimes tell our clients, or our bosses, sometimes if we're working for institutions, we have to let's just slow down a bit, because the last thing we want to do is be before Judge Davis White or Judge Hodge or whatever on an injunction. So there we are. And Paul, of course, you wouldn't want to be advising your clients to leave premises in a state of disrepair without telling them exactly what the likely downside is going to be when landlords surveyors go in there.
From the perspective of the occupier who is vacating, obviously that's an issue in terms of their exposure to dilapidations. From the owner of the property's perspective, usually they want to maximise their income from the dilapidations, but at the same time plan for the evolution of that property going forwards. And if you are in fact buying that property that's between its two chapters of its life, you need that advice from you guys, from a planning and legal perspective, to be bang on the button. Otherwise, you're going to pay over the odds for that property.
Absolutely right.
It's the joined up advice that Nicola and you, Andrew, were referring to there. It does need to be joined up, and it needs to reflect the fast evolving landscape that we're working in right now.
Yeah.
If anybody does think of anything, then please do send me an email and I will forward that on to the panelists and we will try to answer it for you if we can. So that just leaves me to say thank you very much for attending, and a big thank you to our panelists, to Nicola, to Andrew and to Paul for their very insightful talks, which we all found very interesting and very useful. And we'll hopefully see you at the next one.